Welcome back to the deep dive. For a while now, we've really been focused on the mechanics of invention itself.
Yeah, things like novelty, non-obviousness, the whole examination process.
Exactly. How you get the patent, how you create that intellectual asset.
But today, well, we kind of flip the script, don't we?
We do.
We're moving from creation to control. The question isn't, is this patentable anymore?
Right. Now it's more like, okay, who actually owns this thing?
Sure.
And how does ownership legally get transferred?
That's the core of it. Today, we're deep diving into MPEP Chapter 300.
And specifically Section 301, ownership and assignability of patents and applications. Our mission really is to break down that legal framework that turns an idea into, well, a tradable asset.
And it's fundamental. This section lays out patents as property rights. That's the whole reason innovation attracts investment, isn't it?
It has to be.
Because a patent isn't just, an idea on paper. It's legally defined personal property, something you can transfer, sell, record, just like a piece of land or building.
Okay, let's unpack that a bit. Patents as personal property under 35 U.S.C. Section 261. I think when most people hear property, they think tangible stuff, a chair, a car.
Right.
So what does calling a patent personal property actually mean for, say, an inventor or a company?
Well, it immediately gives that invention economic reality. It means you can own it, you can sell it outright, you could use it as collateral for a loan, it can be passed down in a will.
Okay.
For investors, it's legal assurance. When they pour millions into developing something, they know they're acquiring an asset that's legally recognized and enforceable.
That makes total sense for driving commerce. But here's the big catch, right? The thing that always trips people up.
Yeah.
Owning the patent, it doesn't automatically mean you can actually use the invention yourself, does it? That sounds like a huge contradiction.
It is probably the most critical distinction for anyone in this field to really grasp. It causes a lot of confusion. Patent ownership gives you the right to exclude others. Stop them from making, using, selling, or importing your invention. It's purely a negative right. Think of it like a shield.
So it's just a legal tool to stop other people.
Exactly. It doesn't give you an automatic affirmative right to practice the invention yourself.
Why not? What stops you?
Well, think about it. Your invention might still rely on technology covered by someone else's earlier patent.
Okay. Blocking patents.
Right. Or there could be regulatory hurdles, environmental laws, safety standards.
Okay, walk us through that classic example you mentioned earlier, the one that really highlights this.
The pharmaceutical one is perfect. So let's say a company patents a fantastic new drug formulation, groundbreaking stuff.
Okay.
They now have the exclusive legal right to stop every other company from making or selling that specific drug.
Right. They block the competition.
They still have to go through years of rigorous testing and get approval from the Food and Drug Administration, the FDA.
The regulatory gatekeeper.
Precisely. Until the FDA says yes, they cannot legally market or sell that drug to patients, even with the patent.
So the patent keeps competitors out, but the FDA approval is what lets them actually sell it, if they tried to sell without approval.
The patent wouldn't help them one bit against health regulation violations. So yeah, the government grants you this powerful right to exclude this boundary, but it's not a free pass to ignore all other laws.
That's a really important distinction. The right to exclude is powerful, but it's limited by that external reality.
Which leads us nicely into how you actually transfer these rights. If you have this powerful yet limited property interest, how do you get it into the hands of, say, a big company that wants to commercialize it?
Right, and MPEP 301 lays out two main ways: assignment and licensing.
Yes, and knowing the difference is absolutely crucial for any IP deal. Let's start with assignment.
Okay.
Assignment is basically selling the title. You're transferring all or maybe part of your ownership, your right, title, and interest to someone else.
Like selling the deed to your house.
Exactly like that. It's a complete transfer of ownership.
And when this happens, you have to record it with the USPTO, right?
You should, yes.
But you mentioned the recording process is ministerial. What does that really mean in practice? What is the USPTO actually doing?
Ministerial means they're essentially acting like a record keeper. They take the document, they file it, and that act serves as public notice that this transfer supposedly happened. And importantly, it authorizes the new owner, the assignee, to take formal actions before the USPTO regarding that patent or application.
But they aren't checking if the deal itself is actually legit.
Nope. They don't review the contract terms. They don't verify if the person selling it, the assignor, actually had the legal right to sell it. That's not their job in this context.
So if I fraudulently try to assign a patent I don't even own, the USPTO might just record the paperwork.
They might.
But that recording doesn't make my fraudulent transfer legally valid in court.
Absolutely not. The validity of the transfer itself, that's purely a matter for contract law, state law, and potentially the courts to sort out if there's a dispute. The USPTO record just reflects who is claiming ownership.
Got it. Okay, so if assignment is selling the whole thing, what's licensing then? Why choose that route?
Licensing is different. You, the owner, keep the title, keep the ownership, but you grant someone else permission to use the invention under specific conditions.
So it's more like renting out a room in your house, not selling the house.
That's a good analogy. You retain ownership, but you let someone else use part of it, maybe for a specific purpose or time.
I imagine you keep a lot more control with a license.
Oh, definitely. Much more control. With a license, you, the patent owner, set the boundaries.
Like what?
Well, the permission could be limited to a specific geographic area, maybe only for use in Europe.
Okay.
Or it could be time limited, say for 5 years, or restricted to a very specific field of use.
Right.
The example used in the materials is quite clear. A software company licenses a patented encryption method, but the license says they can only use it in their products sold in Europe.
And the original owner keeps all the rights for North America, Asia, other uses.
Exactly. They retain full ownership and the flexibility to grant other licenses or use it themselves in other markets.
That's a huge difference. Assignment is selling it off, often permanently. Licensing is controlled permission, keeping the asset in your name.
Right. Now, moving from how rights are transferred to who holds them, ownership structure. It can be simple, one inventor, one company.
Sure.
But often, especially with complex inventions or corporate R&D, you end up with multiple inventors or multiple companies owning it jointly.
Joint ownership. That sounds like it could get complicated.
It introduces really interesting tension, a conflict almost, between how co-owners can act commercially versus how they have to act procedurally before the USPTO.
Okay, let's take the commercial side first. What can co-owners do out in the marketplace? If, say, 3 of us co-invent something and get a patent, and we haven't signed any special agreement.
Right, no contract between you.
Do I need to ask the other 2 for permission before I start making and selling products based on our patent?
This is where the default MPEP rule can be, well, either really liberating or potentially disastrous.
Oh.
The default rule is each co-owner can independently make, use, or sell the patented invention without asking the others for permission.
Okay, independently.
And here's the kicker, without having to share any of the profits they make.
Wait, seriously? I can go out, commercialize our joint invention, keep all the money, and my co-owners can't do anything about it unless we had a contract beforehand.
That is the default rule under U.S. patent law, unless you have a specific agreement that says otherwise. So, if you jointly invent something and don't immediately hammer out a detailed agreement covering profit sharing, who can license it, who can operate in which markets, you're basically giving each co-owner a green light to compete directly against the others using the shared asset.
That sounds like a recipe for disaster, or at least a lot of bad blood.
It often is. It puts enormous pressure on joint inventors or collaborating companies to negotiate really solid agreements early on, ideally before the patent even issues, just to override that default free-for-all.
So understanding that default rule is critical before you enter a joint venture.
Absolutely. Ignoring it or failing to contract around it is a massive commercial risk. It's probably one of the most expensive lessons you can learn the hard way in IP.
Okay, so that's the commercial side. Independence, potential chaos. But you said the rules flip for dealing with the USPTO.
They do. When it comes to procedural matters before the office, the USPTO needs clarity and unity.
What kind of matters?
Things like prosecuting the patent application, responding to examiner rejections, amending claims, or later on, maybe filing for a reissue of the patent.
Okay.
In those situations, joint owners or even partial assignees, they have to act together as a single unified entity.
So going back to our example, if the examiner rejects our application, all 3 co-owners need to agree on the response and sign off.
Essentially, yes. Or authorize one person to act on behalf of all. The USPTO requires that the party taking action represents the entire right, title, and interest in the patent or application.
Why the strictness there?
It prevents procedural paralysis or conflicting instructions. Imagine one owner trying to abandon the application while another is trying to amend the claims to save it. The office needs a single authoritative voice to ensure the actions taken are valid and binding on everyone with an ownership stake. It ensures the integrity of the prosecution process.
Okay, let's circle back to recording those assignments. You said it's ministerial, meaning the USPTO isn't validating the deal itself.
Right.
But it's still crucial for protecting the ownership we've just been discussing. You mentioned two core functions of recording.
Yes. The first, as we said, is public notice, getting the assignment document into the USPTO's official public records database.
So anyone can look it up.
Theoretically, yes, for issued patents and published applications. The second function is more practical, more internal to the USPTO process. It involves recording the document specifically within the file of the relevant patent or application.
And why is that necessary?
That's what formally authorizes the assignee, the new owner, to actually take action before the office concerning that specific file. Things like paying maintenance fees, filing responses, initiating litigation. It links the ownership change to this specific asset file.
Gotcha. And even though the recording doesn't guarantee the transfer was legally sound, you said it's essential for protecting the buyer against later problems. How does that work?
Think of it like recording a house deed. It protects you against a shady seller trying to sell the same property twice. So imagine assignee A sells their patent to assignee B on Monday. But assignee B, maybe they drag their feet and don't record the assignment immediately.
Right.
Then on Wednesday, the same dishonest assignee A sells the exact same patent to assignee C. Assignee C knows nothing about the first sale.
Okay, a secret second sale.
Right. Now, assignee C is diligent. They immediately rush to the USPTO and record their assignment document.
Who owns the patent now? Assignee B bought it first.
But assignee C recorded it first. If assignee C paid fair value for the patent and genuinely didn't know about the prior sale to B, making them a bona fide purchaser for value, then assignee C likely gets the valid title.
Wow. Even though B bought it first.
Yes, unless assignee B had recorded their assignment before C purchased it. That act of recording serves as constructive notice to the whole world. It basically says, hey, everyone, this patent now belongs to B.
So recording protects the first buyer's rights against any later buyers who might acquire conflicting interests without knowing. It secures their place in the chain of title.
Exactly. It's fundamental protection in the marketplace. That's the real legal teeth behind recording.
Okay, that makes the importance clear. Now, about transparency. How easy is it for someone, maybe an investor doing due diligence, to actually see these records?
For issued patents and applications that have been published, the assignment records are generally open for public inspection.
Where do you look?
The main place these days is the USPTO website. They have an online database where you can search for and view images of assignment documents recorded since around June 1998.
So most modern transactions are easily searchable online. What about older stuff? Patents from, say, the 1950s or even earlier?
For those really old historical records going way back, sometimes even into the 19th century, those documents are maintained separately. They're held by the National Archives and Records Administration, or NARA.
Okay, so there's a path for historical research, too. And what about applications that are still pending and haven't been published? Those records must be kept confidential, right? To protect the inventor's secrets.
Absolutely. The assignment records related to unpublished or otherwise confidential applications are generally not open to the public. Confidentiality is key there.
But you mentioned an exception.
Yes, there's a specific carve-out. Access can be granted to certain authorized parties.
Like who? The inventor, the assignee.
Yes, them, of course. But also, interestingly, to someone who can prove they are a bona fide prospective purchaser of the patent rights.
Wait, someone who's just thinking about buying it can get access to confidential assignment records. Why?
Because they have a legitimate, substantial business reason. If a major corporation is negotiating, say, a multi-million-dollar acquisition that hinges on that pending application, they need to be able to verify the chain of title and the status of assignments before they commit that kind of money.
So it's a necessary evil, almost. A limited breach of confidentiality to allow high-stakes deals to actually happen based on verified information.
Exactly. It balances the need for confidentiality with the practical realities of technology transfer and investment. Hashtag tag outro ping.
Well, this deep dive into MPEP Section 301 really underscores how patents are treated as serious, legally defined assets. These aren't just random rules.
Not at all. They're designed to provide clarity on who owns what, transparency through public records, and ultimately build that reliable legal infrastructure that makes investment and innovation worthwhile.
And understanding those key distinctions is vital.
Absolutely. The difference between the right to exclude and the right to practice. And that weird conflict between acting independently in the market but needing unity before the USPTO for joint owners.
Yeah.
Getting those right is often the difference between a smooth IP strategy and, well, ending up in court fighting your own partners.
So thinking about what this means for you, the listener, maybe the biggest takeaway is that inherent tension in the default rules for joint ownership. Consider how those defaults, where co-owners can compete freely commercially, but must act together procedurally, how that must shape every single negotiation for a joint development agreement.
It forces your hand, really.
Right. You basically have to create a contract to override those default rules just to establish clear expectations and protect everyone involved.
That need for proactive, detailed legal planning, often very early on, that's the core lesson here. You need to sort out your commercial relationship long before your product hits the market.
Definitely something to keep in mind.
Yeah.
Now, before we wrap up, we want to extend a special thank you.
Yes, to Mike Shepard, the creative director who organized this entire audio series. His work has been invaluable in making this complex patent law material accessible and hopefully engaging for everyone listening, students, professionals, innovators.
Absolutely. His efforts have made this possible.
And finally, our standard but crucial disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM. It might contain errors or omissions.
Right. It's for general educational and informational purposes only. It is definitely not legal advice and no substitute for formal instruction.
For authoritative guidance, please always consult the official MPEP itself, a qualified instructor, or a registered patent practitioner.
Thanks for joining us. We'll catch you on the next deep dive.